We are covering chapter 2, types of companies. Types of companies, section 3 describe three types of companies: private, public and one person company. Private company, there must be minimum 2 members and maximum 200. Public company, minimum 7 members, and one person company, there will be only 1 member. All the above companies can be formed under 3 ways, that is limited by shares, limited by guarantee, or as an unlimited company. Now let's say classification of companies on 3 different bases. First, classification on the basis of incorporation. There are 2 bifurcation: statutory companies and registered company. Statutory company means a company incorporated by special act of parliament or state legislature. For example, LIC, RBI, etc. On the other hand, registered company means a company formed and registered under the Companies Act. For example, Tata Steel Limited, Reliance Limited, etc. On the basis of liability, there can be 3 bifurcation, as we have already seen: unlimited liability company, liability limited by guarantee, and liability limited by shares. Again, the companies can be bifurcated on the basis of their form, in like association, not for profit, this is section 8, this is important company; government company, foreign company, holding and subsidiary company, associate company, investment company, dormant company, producer company, and small company and one person companies. First we will see private company. It is defined under section 268 of the Companies Act 2013. A company which has paid up capital, minimum paid up capital of 1 lakh, and which by its article restrict the transfer of shares, limits the member to up to 200, and prohibits the invitation to public to subscribe securities. 200 does not include present and past employees who are also the members. Use of the word private limited at the end of its name is compulsory for private limited company. Section 149 says that private company should have minimum 2 directors. Further, private company can be classified as one person company and small company. The question can be asked about the obligation of a private limited company. Obligation ka matlab, what exactly a private company has to do? It is under section 268, it is said that private company must give a certificate with the annual return. That is, every year private company must give a certificate that it has not invited public to subscribe its securities, its member does not exceed 200 limit, and even if it exceed, it comes under the exclusions. It continue to be a private company throughout the financial year. This is the certificate the private company has to file along with the annual return. This is the obligation of private limited. Now let's see about one person company. Section 262 describe one person company means a company having only one person as a member. Member must be 1 and directors minimum 1. So it can have more than 1 also, but minimum 1 director. It can be limited by shares, guarantee, or unlimited company. Important provisions are contained under Rule 3 of Companies Incorporation Rules 2014 regarding one person company. These are: member or nominee of one person company can be only natural person who is Indian citizen and the resident of India. Here the resident means who stayed in India minimum 182 days in the preceding calendar year. No person can incorporate or become a nominee of more than one person company. If by chance a member becomes member in another one person company because of nomination, it should meet the criteria of being a one member of only one person company within 180 days. Minor cannot become a member or cannot become a nominee or cannot beneficially hold the shares of one person company. Total ban on minors. Cannot be incorporated as or converted into section 8 company, non-profit organization. Cannot carry out non-banking financial investment activities. Further, it cannot be converted into other forms of company within 2 years of its incorporation, except when its paid up capital exceed 50 lakhs or average annual turnover exceed 2 crore. Contract with member director means one person company can contract with a member who is also a director of that company. A special provision section 193 says that a contract by OPC with a member who is also a director, unless in writing, be recorded. So if it is oral, it should be recorded in the memorandum of the company or in the minutes of the meeting, except when such contract is entered into ordinary course of business. So here you have to remember, if it is recorded in the minutes, then the ROC should be informed about such minutes within 15 days of the meeting. The important 2 points here are, if a contract is with only member who is not a director, this provision will not apply. And again, if it is in writing, contract is in writing, then again this provision will not apply. Small company, section 285 describes small company means a company other than public company which is having a paid up capital of 50 lakh rupees or less or higher, not beyond 5 crore. It means 50 लाख की जो लिमिट है वो गवर्नमेंट 5 करोड़ तक एनहेंस कर सकती है. फॉर द टाइम बीइंग यू हैव टू रिमेंबर पेड अप कैपिटल जिसकी 50 लाख है उससे कम है. एंड सेकंड, टर्नओवर एज पर द लास्ट P&L इज लेस देन 2 करोड़. अगेन 2 करोड़ को गवर्नमेंट कैन इंक्रीज अप टू 20 करोड़. सो प्रेजेंटली स्मॉल कंपनी मींस अदर देन पब्लिक जिसकी पेड अप कैपिटल 50 लाख या उससे कम है और टर्नओवर in the last P&L is 2 crore or less. Now important exceptions: holding or subsidiary, non-profit organization, that is section 8, and special act companies cannot be treated as small company. These exceptions are important. These three can never be treated as small companies. Now let's see public company. Section 271 described a company which is not a private company and which is having a minimum paid up capital of 5 lakh rupees. Again, important note is subsidiary of any public company is also treated as public company. Public company must have minimum 3 directors and must have minimum 7 members. Limited company is defined under 3(2), means a company limited by share or guarantee. Limited by share means liability is limited to the amount unpaid on the shares, and limited by guarantee means liability is limited up to the amount guaranteed. Unlimited company has been defined under section 292, like company not having any limit on its liability. So the liability may stretches to personal property of the members, but the members are not directly liable to the creditors. Only liquidator can ask member to contribute in the event of winding up. However, this unlimited company may convert into a limited liability by altering its memorandum or articles of association. Association not for profit. This is also called section 8 companies. This is important from exam point of view. Section 8 permits registration of association not for profit as a company. A license may be granted by central government subject to following 2 conditions. ये conditions important है. First of all, the object of the association must be promoting commerce, arts, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other objects, and which prohibits payment of dividend to its members. So these 2 important conditions you have to remember. Another important points, few more important points: a firm may become a member of such company. Normally a firm cannot become a member of any other company, but this company, a firm, can become a member of such company. Such companies cannot alter its memorandum without previous approval of central government, and such company may or may not use the words limited or private limited at the end of its name. Now government company, section 245 defines the government company in a company in which minimum 51% paid up capital is held by central government, state government, or partly by central government or state government. So minimum 51% of the paid up capital. This you have to remember. Notes: there are two important cases you can quote: Hindustan Steel Works Limited versus State of Kerala. Such company is neither a government department nor government establishment, and the employees of these companies cannot be treated as government servant. Another case, Andhra Pradesh Road Transport Corporation versus Income Tax Officer. These companies are not exempt from tax under Article 289 of the Constitution. This article basically exempts government department from paying taxes. Now, foreign company, Section 242 defines foreign company means a company or a body corporate incorporated outside India and which has a place of business in India and conducts business activities in India. So these two are the important condition for any company or body corporate to be treated as foreign company. There is a famous case law of Johnson that following activities are not considering carrying on business. So you can note down these also. Now let's see holding company. 246 says a company of which other company or companies are subsidiaries is called a holding company of those companies. Subsidiary company, section 287 describe the word subsidiary company. A company in which holding company controls the composition of board of director or holds or control more than 50% of the total share capital, more than, not 50%, more than 50%. Either alone it controls or together with other subsidiary companies, provided such holding should not have layers of subsidiary beyond prescribed limit. Now what is prescribed limit? The government will prescribe this limit and we have to wait for that. Other points, total paid up capital. Here total share capital means the total paid up capital, equity and convertible preference shares. So if the preference shares are convertible, you have to consider that also for calculating 50%. Section 19 says that subsidiary cannot hold shares in holding except as a legal representative, as a trustee, or if it has already held the shares in the holding company. Associate company. Section 26 says that a company in which other company has a significant influence. ये word याद रखना, significant influence, but which is not a subsidiary, and it includes a joint venture company. Now significant influence have been separately described as means controlling at least 20% of the share capital of the company or controlling business decision as per the agreement. So you can call it a significant influence. Section 276 says that associate company will be treated as a related party and hence contract with associate company will require disclosure, approval and entry in the register as well. Now there are two more definitions of different companies but are not that important. Investment company 186 says that whose principal business is acquisition of share, debenture or security, that is investment company. Producer company, it is still governed by part 9A of the Companies Act 1956 till new act is enacted for this type of companies. Section 581A of the Companies Act 1956 says it's a body corporate with objects mentioned under 581B and the membership of such companies open for those who are primary producers. Now let's see dormant company. Section 455, a company which is formed and registered for future projects or to hold assets or intellectual property and has no significant transactions, then it can be treated as dormant company. However, an inactive company may also make an application to ROC to get a status of dormant company. Now the ROC will maintain a separate register of dormant companies and dormant companies need to have such minimum number of director, file such document and pay such fees as may be prescribed, and such dormant company may become active by applying to the ROC. Now the special privileges of dormant companies are that section 240 says that the financial statement may not include cash flow statement of, so this is a privilege. And second, section 173 says that minimum one board meeting in each calendar half calendar year में only one meeting board meeting करना है. And second is minimum gap between two board meeting must be 90 days. Both these are very important point from exam point of view. Now let's see, public financial institution defined under section 272 means LIC, IDFC, companies specified under UTI, an institution notified by central government under this act or in consultation with the Reserve Bank of India. As far as notification of institution is concerned, cannot be notified unless formed under special act, and minimum 51% of the paid up capital is held or controlled by central government, state government, or partly by central or state government. Now the question can be asked about the statutory corporation, or they can ask principal characteristics of statutory corporation. So these are the important points about statutory corporation. Owned by the state, it is created by special act, there is an immunity from parliament scrutiny in its day-to-day affairs, employees are not civil servant, they don't get the protection under article 311 of the constitution, it's a body corporate, it has a distinct relation with the government, so government may direct it in policy decision with regard to public interest. Independent finance, operate on business principles, audited by CAG, except bank, financial institution and LIC, the audit is done by chartered accountant. Now this is very important question that can be asked in the exam, whether corporations are state or not. So in the past, statutory character was the basic criteria for deciding whether a corporation is a state under article 12 of the constitution or not. This was the ruling in case of Mohan Lal, where Rajasthan State Electricity Board was treated as a state. But now, after the case of International Airport Authority versus Raman Dayaram Shetty, this is the landmark decision, it was given in this case by Justice Bhagwati. It said that how the corporation was born is irrelevant. Following is the criteria to decide whether a corporation is a state or not. Sources of share capital, extent of state control, monopoly status, functions of public importance, and whether it was formally a government department. But at the end, the Justice Bhagwati also clarified that this list is neither conclusive, so other points may also be considered, nor exhaustive. Finally, it is not that these points matter, there may be other points which you can consider to decide whether a corporation is a state or not. There are two important cases which you have to quote in this regard. First case is Som Prakash versus Union of India, in which it was said that writ petition is maintainable against the state, and Ajay Hasia versus Khalid Mujib, in which it was decided that the Regional Engineering College of Srinagar, being a state, must follow the principle of equality in its admission. And this is the end of the chapter number 2 of company law. If you have any doubt or query, you can call it this number and try to revise and give test. Try to revise at least 2 times this chapter.